Hello friends, welcome to EPG Pathshala. I am Professor S.P. Singh from Faculty of Management Studies, Gurukul Kangadi University, Haridwar. Today we are going to study Module 36 on collective bargaining. Friends, after studying this module, you shall be able to know the concept of collective bargaining, understand the characteristics of collective bargaining, comprehend the objectives of collective bargaining, become aware of the participants of collective bargaining, know the process of collective bargaining, list the bargaining issues, know the administration of the agreement. Friends, collective bargaining is a process which regulates the terms and conditions of workers by agreements between their bargaining representatives and employers. Collective bargaining takes place when representatives of employees enter into negotiation as a bargaining unit with an employer or group of employers with the object of reaching an agreement on the working conditions. Collective bargaining is a complex process. It involves psychology, politics, and power. It is the continuous relationship between an employer and a designated labor organization representing employees for the purposes of negotiating terms of employment. Collective bargaining is an agreement between a single employer and an association of employers on the one hand and the representatives of the labor on the other, which control the terms and conditions of employment. Therefore, collective bargaining may be expressed as an agreement under which the organizations of workers and employers collectively attempt to resolve their differences with or without the help of a third party. A negotiation is a group does initiated by the representatives of the group as opposed to individual action is collective bargaining. It is flexible and mobile and not fixed or static and has enough scope for a mutual give and take before the finally agreeing. It is a two-party process. Both parties are involved in it. It is a continuous process which provides framework for continuous and organized relationship of the two parties. It is dynamic, growing, expanding and changing concept. In the present time, it is scientific, factual and systematic. Negotiations constitute an important aspect of the process of collective bargaining. Collective bargaining is a process beginning with the presentation of the Charter of Demands and ends with reaching an agreement. This agreement will govern the labor management relations over a period of time in an enterprise. It is a complementary process. Each party needs something that the other party has. Collective bargaining tends to improve the relations between workers and the employer. Collective bargaining uses cooperation and consensus for settling disputes. Collective bargaining takes into account day-to-day changes, policies, potentialities, capacities and interests. The institution of a collective bargaining has benefits for the present as well as for the future. The objectives of collective bargaining are to facilitate a solution acceptable to the parties involved, to provide the workers opportunity to voice their issues related to employment, to resolve all conflicts and disputes in an amicable manner, to attempt prevention of strikes, lockout, and enhance the productivity of the organization, to develop a conducive atmosphere to foster good industrial relations, to prevent any future conflict, dispute through mutually signed contracts, usually, the two parties participate in the process of collective bargaining. The two parties are management and labor. Management's representative in collective bargaining talks tends to depend on the size of the organization. In a small firm, the bargaining is probably done by the president. In medium-sized firms, bargaining is typically accomplished by the personnel manager, who is often supported by outside legal assistance. In large organizations, there is usually a sophisticated personnel department and industrial relations experts. In such cases, the senior manager for industrial relations, corporate executives, and company lawyers represent the management. On the employee side, a bargaining team consisting of officers of local union and representation from national union comprises the bargaining team. In case of negotiations involving a contract covering large number of employees, national union leaders will dominate the bargaining team, supported by strong economic and legal experts. Whenever there is an impasse or deadlock of dialogue between the management and the union, a third party, government, intervenes in the process. In addition to providing the rule according to which collective bargaining takes place, government provides a watchful eye on the two parties to ensure the rules are observed. The financial institutes often also play a role in collective bargaining. Although not directly involved in negotiations, the banks set limits on the amount that the company can spend in upcoming negotiations. Exceeding that amount may cause the banks to call in the loans made to the company. This puts a ceiling on the management's spending. 5 stages are involved in the bargaining process: pre-negotiation, negotiators, negotiation, agreement or contract, and implementation of agreement. Preparations for negotiation is the first stage involved in a bargaining process. The pre-negotiation stage of the bargaining process is vital, as is confirmed by the fact that up to 83% of the results of the negotiations are much influenced by pre-negotiation stage. The workers and the management need to prepare themselves for bargaining. The management has to study and analyze carefully the labor organization with which they are to negotiate or bargain. This may include studying the strength of the union, the background and personal traits of the negotiators, etc. The management should also understand what similar organizations are doing in the particular matter. The management should understand the bargaining power of the union and accordingly formulate its bargaining strategy. Finally, the management should also chalk out the probable decisions. The labor union also needs to collect data on relevant aspects of organization so that they are in a position to negotiate with power and tactics. It should understand its contracts with other enterprises, the practices other companies follow in the same region, and so on. Assess employees' expectations over various issues to avoid their resistance to the agreement arrived. Negotiator representative of the union should also be selected with due care. Negotiators. On the company side, the particular negotiator may be anyone of a number of persons, such as the industrial relations officer, the head of the specific area, such as production, an office bearer, or even the company lawyer. In order to broaden the base of participation, permitting all major divisional heads for participation and a few supervisors to observe has great advantages in bargaining process. On the union side, the team approach is often applied. The team may comprise of business agents, shop stewards, the president of the plant union, and when the negotiation is vital, the president of the national union. Negotiation. After completing the first two stages of the process, the workers' representatives and management arrive to the negotiating table at a time and place for this purpose. Traditionally, negotiation process begins by the union representatives submitting an exaggerated and long charter of demands. The initial response from the management is usually as extreme as that of the union. The management counters the demands of the union by proposing to give little more than agreed in the previous contract. Thus, each group gives up some of its demands and compromises so that an agreement can be reached when they actually arrive at an agreement. This is converted into a written contract. In case no agreement is reached, then it is called breakdown of the bargaining. Agreement or contract. After both parties have arrived at an informal agreement, either in the normal initial process or through overcoming bargaining impasse, it is written. The collective bargaining agreement usually consists of the terms and conditions of agreement, the date from which it comes into effect, the duration for which it will remain in operation, and the names of the signatories to the agreement. The agreement is then sent to the workers and management for ratification and approval. The union members and management both receive copies of the agreement. The agreement stipulates the nature of the relationship between labor and management for the ensuing period of time as agreed in negotiation. There are certain issues of collective bargaining between the labor and management. These include recognition of the trade union, management's right, union security, compensation and benefits, a grievance procedure, employee security, job-related factors, administration of the agreement, and compensation and benefits. Friends, in this module, you have studied the concept, the characteristics, the objectives, the process, the participants, and issues of collective bargaining. You have also studied the administration of the collective bargaining agreement. Thanks for visiting EPG Pathshala.